Good evening, everyone. I am happy to present presentation on e-appeals scheme 2023, which was notified on 29th May 2023. This is basically relating to JCIT appeals, which has been created by this Finance Act 2023. During this presentation, though the topic, when I was preparing on the face of it, the topic looked very small. I thought that we can easily complete it in 1 hour. But when I started going deep into the subject, so I could get more issues or more matter. So I have decided to take up the specific matters relating to e-appeals in detail, and some of the things which are common to CIT appeals and JCIT appeals, I will touch upon that, and I will go through in detail about the JCIT appeals. Whatever questions you have, you can, as the organizers have told, that you can put it in the chat box. First, I would like to complete my presentation within the time allowed. Then we will go for question and answers. So we will begin with JCIT appeals presentation. Now, in the brief, what synopsis I will going to take it. I'll be dealing with this memorandum explaining the provisions of finance bill, why this scheme is introduced, then what are the appealable orders before the Joint Commissioner appeals, then what is the e-appeals scheme which was notified on 29 May 2023, then the scope of e-appeals scheme. This was published on 16th June 2023. So this is all very useful, which I am going to take. Then some other things are also there relating to the amendments in the rules, then appointment of JCIT appeals all over the country. About 100 JCIT appeals have been appointed. Then Form 35, which has been this form of appeal before the CIT, that has also amended. Then we will take up the question and answers. Now, why this memorandum? Why this JCIT appeals authority is introduced? Now, the finance minister in this memorandum said that the first authority of appeals, CIT appeals, are currently overburdened due to high number of appeals and pendency. High number of appeals and pendency, which being carried on every year. Now, in order to reduce this pendency, new authority of appeals is created as JCIT or Additional Commissioner Appeals. The powers, responsibilities and accountabilities are similar to the Commissioner Appeals. Now, I request the participants to just avoid noting down anything, because anyway this PPT will be shared to you, and when I'm displaying this slide also, you can just see the words marked in red lights, so that our time can be saved, and important things I have already marked in red light, red color. Now, the earlier section 246 was which provided for DCIT appeals was discontinued in the year 2000, and then now in the same 2246 section 246, the authority of JCIT appeal has been created. Now, what is the section 246? Now, section 246 says that any assessee aggrieved by the following orders of an assessing officer, but the assessing officer should be below the rank of Joint Commissioner, then these orders may be appealed before the Joint Commissioner. Now, what are these orders? An intimation under 143(1) and an order of assessment under 143(3) or 144 are one of the orders which can be appealed before the JCIT appeal. Then an order of assessment or reassessment under section 147. Whatever the relevant section is there, I have mentioned in blue color on my slides for ready reference. Now, an order being an intimation under subsection 1 of section 200A. Section 200A is relating to processing of statements of tax deducted at source. Then an order under section 201, consequence of failure to deduct or pay tax. Then an order being an intimation under subsection 6A of 206C. What is this section? It is a failure to collect or deposit TDS. Then an order under subsection 1 of section 206CB relating to processing of statements of tax collected at source. Then an order imposing a penalty under chapter 11, which relates to all penalties which are imposable under Income Tax Act. Then an order relating to 154 or 155, amending any of the orders mentioned by me in the last preceding slides from A to G. Now, section 154, as we all know, is relating to rectification of mistakes, and section 155 relates to amendment to assessments consequent to assessment or reassessment of connected entities. Now, provided that no appeal shall be filed before Joint Commissioner Appeals, if an order referred to in this subsection is passed by or with the prior approval of an income tax authority above the rank of Deputy Commissioner. Now, the above the rank of Deputy Commissioner is Joint Commissioner. So, whenever any order is passed by any income tax authority below the Joint Commissioner of Income Tax, those orders can only be appealable before Joint Commissioner Appeals. Now, section 246(2) relates to the situation where any appeal filed against an order referred to in section 1 is pending before the CIT appeals. The board or any income tax authority so authorized by board may transfer these appeals to the Joint Commissioner Appeals from the stage at which it was before it was so transferred. So Joint Commissioner Appeals, whenever the appeal will be transferred to Joint Commissioner Appeals, he will take up the appeals from the stage from at which it was there before it was transferred to him. Similarly, the board or income tax authorities so authorized may transfer an appeal which is pending before a Joint Commissioner Appeal to the Commissioner Appeals whenever the situation warrant that. Now, where an appeal is transferred under the provisions of subsection 2 or subsection 3, the appellant shall be given an opportunity of reheard. Whenever there is a transfer of appeal, the authority before which the officer before which the appeal is transferred, the case is transferred, should give an opportunity of rehearing to the appellant. Now, for the purpose of disposal of any appeal by the Joint Commissioner Appeals, the central government may make a scheme. So, the central government is having a power to make a scheme. That scheme is made by name e-appeals scheme on 29th May. Now, for the purpose of subsection 1, the board may specify that the provisions of that subsection shall not apply to any case or any class of cases. Whenever the board decides that some particular class of cases or classes of case, any particular class of case is to be excluded from the purview of the Joint Commissioner Appeals, then it has the power to exercise such powers under section 246(6), which have been exercised on 16/6/2023 by way of scope of e-appeals scheme. Now, what is the major difference between the faceless CIT appeals scheme and e-appeals scheme? Now, what I find is that in faceless CIT appeals scheme, all communication was through faceless appeal center. So the appellant was unable to know who is the CIT appeals there. But all the communication used to be through the faceless appeal center. Now, in this case, in this e-appeals, there is a direct communication between the JCIT appeals and assessing officer and other income tax authorities and the appellant, but by way of e-communication. It is not a physical personal communication, but this communication is by way of e-communication, but the appellant will be able to know who is the JCIT appeals. Whereas in the case of CIT appeals, the appellant is not able to know who is the CIT appeals. This is one of the major difference I found in this appeal and CIT appeals. Now, we will go through this e-appeals scheme. What is this e-appeals scheme? Now, this e-appeal scheme, now definitions part I am leaving because definitions part are almost same what is there in the CIT appeals. So means because of a constraint of time, I am just avoiding to read all these definitions so that I can take you to more important aspects during the allowed time. Now, the scheme shall apply to appeals covered under Section 246 of the Act, except the cases excluded under subsection 6 of that subsection. So, this is the applicability of the scheme. Now, appeal authority, as I said, in this is Joint Commissioner of Appeals, which is also called as Additional Commissioner. Now, the appeals, the principal, who will allocate the appeals? The appeals will be allocated by the Principal Director General of Income Tax Systems or the Director General of Income Tax Systems shall devise a process to randomly allocate or transfer the appeals referred to above. So, the Principal Director of Income Tax Systems or Director of Income Tax Systems will be the authority allocating the appeals. Now, procedure. What is the procedure in this appeal? The following procedure will be followed while disposing of this appeals. Whenever the appeals are assigned to JCIT appeals, he may condone the delay in filing the appeal. The provisions relating to condonation of delay are same what is there in the CIT appeals. So, the JCIT appeal shall give notice to the appellant asking him to file his submissions, and he will also send a copy of such notice to the assessing officer. Whenever an appeal is filed and put for hearing, the JCIT appeal will give a notice to the appellant asking him to file his written submissions, and also simultaneously he will issue a copy to the assessing officer. Then the JCIT appeals may obtain further information, document or evidence from the appellant or any other person required for the purpose of disposal of the appeal. The JCIT may obtain a report from the assessing officer on the grounds of appeal or information, document or evidence furnished by the appellant. He may request the assessing officer for making further inquiry under subsection 4 of section 250 of the Act and submit a report, which we commonly refer to as a remand report. So, the JCIT appeals will have power to obtain the remand report. He shall serve a notice upon the appellant or any other person or the assessing officer to submit information, document, evidence or report. Not only written submissions, he may also ask the appellant or any other person relating who has a whose submissions or whose involvement in the appeal will have a bearing on the appeal or assessing officer to submit any information, document or evidence or report. The appellant or any other person, as the case may be, shall furnish response as required in the given subclauses. The assessing officer shall furnish a report as required whenever it is asked during the specified time or the extended time. The appellant may file additional grounds of appeal. The appellant is, as in case of CIT appeals, here also is an authority to file additional grounds of appeal. So, whenever an appellant files additional grounds of appeal, the JCIT appeal shall admit such ground of additional ground in case of orders passed under subsection 1 of section 143 of the Act. Whenever any appeal is filed against subsection 1 of section 143(1) or section 200 capital A relating to processing of statements of TDS. So, whenever the appeals are filed relating to under these sections, then relating to the addition means relating to the assessments made or intimation made under this sections, then the JCIT appeal shall admit such additional grounds. He has no choice whether to admit or not admit. He should straight away admit the additional grounds in this situation. Now, in any other case, the JCIT appeal shall send the additional ground to the assessing officer for obtaining his comments. Then the assessing officer shall furnish his comments within the time specified or extended time. Then the JCIT appeal shall, after taking into consideration the comments, if any received from the assessing officer, admit the additional ground or not admit the additional ground. The appellant may furnish additional evidence, like in CIT appeals. Here also the appellant can furnish additional evidence. Now the additional evidence, whenever is furnished, the JCIT appeal shall admit such additional evidence. Similarly, in case wherever the orders are passed under 143(1) or 200A, section 200A, then without asking any question, the JCIT appeals should admit the additional evidence. There is no choice whether to admit or not admit in this situation. But in any other case, the additional evidence is filed, then shall the JCIT appeal shall send the additional evidence to the assessing officer for obtaining his report. Then the assessing officer shall furnish the report, and then the JCIT appeals may, after considering the additional evidence and report, if any, received by the assessing officer, admit or reject the additional evidence. Now, the JCIT appeal shall, if he admits such evidence before taking such evidence into account in the appellate proceedings, then prepare a notice to provide an opportunity to the assessing officer to examine such evidence or to cross-examine such witness as may be produced by the appellant. So this opportunity, when the additional evidence is admitted, this opportunity should be given to the assessing officer by the JCIT appeals, and or to produce any evidence or document or any witness in rebuttal of the evidence or witness produced by the appellant. So whenever this situation arises, the assessing officer should be given the one more opportunity to rebut the evidence or witness produced by the appellant. Then the assessing officer shall furnish the report within the time allowed by the JCIT appeals. Then the assessing officer may request the JCIT appeals to direct the production of any document or evidence by the appellant or the examination of any witness as may be relevant to the appellate proceedings. Now, the JCIT appeals may, if it deems fit, send a notice directing the appellant to produce such documents or evidence for examination of any other person being a witness. Then the appellant or any other person, as the case may be, shall furnish his response to the said notice referred above. Now, where the JCIT appeals intends to enhance an assessment or a penalty or reduce the amount of refund. Now similarly, in case of CIT appeals, JCIT appeals has also got the power to enhance the assessment. So whenever there is whenever he wishes to enhance the assessment or penalty or reduce the amount of refund, then the JCIT shall prepare a show cause notice containing the reasons for such enhancement or reduction as the case may be, and shall serve the notice upon the appellant. So whenever the opportunity should be given to the appellant. Now, the appellant shall, whenever this opportunity is given, then he should, within the specified time or in the extended time allowed by the JCIT appeals, furnish response to the JCIT appeals. Now, the JCIT appeals shall thereafter prepare in writing an appellate order in accordance with the provisions of section 251, stating the points for determination, the decision thereon, and the reason for the decision. Now, whenever the enhancement is made, the JCIT appeals should state the points for determination of the enhanced amount, then the decision, why he has taken the decision, and the reason for taking the decision should be incorporated in the appellate order in a speaking manner. Then he should send the such order after signing the same digitally to the appellant, along with the details of penalty proceedings, if any, to be initiated thereon. And the copies should be sent to the Principal Chief Commissioner or the Chief Commissioner as required under section 257. And a copy should be given to the assessing officer for such action as may be required under the Act. Now, where initiation of penalty has been recommended in the order, then he should serve a notice upon the appellant calling upon him to show cause as why the penalty should not be imposed upon him. During the proceedings before JCIT appeals, if the assessee or the appellant or any other person does not cooperate, the the JCIT appeal has power to initiate and levy the penalty. So in that case, this procedure is to be followed. Now, notwithstanding anything contained in paragraph 1, the appeal may be transferred at any stage of the appellate proceedings if considered necessary by an order in accordance with section 120 of the Act to such JCIT as may be specified in the order. So, there is a power to transfer, a power under section 120 to transfer the case from one JCIT appeals to another JCIT appeal during the proceedings partly heard. Now, coming to penalty proceedings, now the procedure being the same, I am not going into the detail of penalty proceedings, procedure of penalty proceedings. So, this is a part of my PPT which will be shared to you, but due to constraint of time, I am not taking into the detail because it is a repetition. Procedure is a repetition. Now, in case of rectification of proceedings, now, whenever there is a mistake apparent from the record, the JCIT appeals may amend such order passed by it in accordance with the provisions of the Act by an order to be passed in writing, rectification order. Now, an application for rectification of mistake may be filed by whom? By the appellant or any other person, as the case may be. If the appellant is affected or if any other person is affected, he may file a petition for application for rectification of mistake, or the assessing officer, if he feels that there is a mistake apparent from record, the assessing officer can also file a application for rectification of mistake before the JCIT appeals. Now, this procedure is also same. So, now the JCIT appeals has power to rectify the mistake or for reason recorded to be in writing, reject the application for rectification. Whenever there is a there is an acceptable mistake, the JCIT will rectify the mistake. And whenever he is not agreeing with the mistake apparent from the record, he should record the reasons for rejection of application. Now, the JCIT appeal shall send the order after digitally signed. Then this rectification order should also be sent in the same fashion in which we discussed that the appellate order is to be sent. Now, the appellate proceedings. Now, the appeal against an order passed by the JCIT appeals will lie with the Income Tax Appellate Tribunal, having jurisdiction over the jurisdictional assessing officer of the appellant assessee. Now, the appeal will lie with the Income Tax Appellate Tribunal, having jurisdiction over the jurisdictional assessing officer of the appellant assessee, having the jurisdiction over the jurisdictional assessing officer of the appellant assessee. Now, subject to the provisions of so and so, where any order passed by the JCIT appeals set aside and remanded back to the JCIT appeals by Income Tax Appellate Tribunal or High Court or Supreme Court, the order shall be once again assigned to JCIT appeals for further action in accordance with the provisions of the scheme. So, all the set aside orders of the JCIT appeals will again be allocated to the JCIT appeals as per the provisions of the scheme. Now, mode of communication. All communication between the JCIT appeals and the appellant or his authorized representative shall be exchanged by way of electronic mode to the extent technologically feasible. All communication, as I told in the beginning also, should be by electronic mode only. No physical hearing will be given. All internal communications also. Internal communications between the JCIT appeals, the assessing officer, the principal chief commissioner or any other authority within the department will also be through the electronic mode only. Now, authentication of electronic record. So, electronic record shall be authenticated by affixing the digital signature of the JCIT appeals. He should affix the digital signature for authenticating the electronic record. The appellant or any other person, how he should authenticate the record? The appellant should authenticate the record, or any other person should authenticate the record by affixing his digital signature or under electronic verification code EVC by logging into the registered account in the designated portal. In the registered account of the appellant in the income tax portal, he should file this by way of affixing his digital signature or EVC. Now, the delivery of electronic record, how it should be delivered? Every notice or order or any other electronic communication under the scheme shall be delivered to the addressee, being the appellant. How the electronic record should be delivered to the appellant? It should be delivered by placing an authenticated copy thereof in the appellant's registered account in the income tax portal. In the appellant registered account, it should be placed. Number one, it is one mode. Then or it is or is mentioned. Then it is not and, it is or. Then sending an authenticated copy thereof to the registered email address of the appellant or his authorized representative. The second choice for this JCIT appeals is to send an authenticated copy thereof to the registered email address of the appellant. Now, when it comes to registered email address of the appellant, if we go through the definitions in the email IDs, in the definitions, the email ID, like in case of this scrutiny assessment or CIT appeals, the definition of email ID, it contains so many options. It gives so many options for the income tax authority to send the any of the mails which relates to, means the email mentioned at the time of PAN. Some of the things I am saying are in MCA portal or in the last return or is authorized representative email address. So any of the email address it can be sent. Then we have seen that during last few years, lot of litigation has arisen because of this only, because the department has sent the notices and orders to the email address which were not in operation by the appellant or his authorized representative. So it amounted to passing the order ex parte. Now, for that purpose, huge demands have been raised. Now, these things are more under litigation during last few years. So we have to be very careful in monitoring this email address from the appellant side. Now, uploading the authenticated copy on the mobile app of the appellant, followed by a real-time alert. Now, the mobile app also of the appellant can also be authenticated there, followed by a real-time alert. Now, when it comes to real-time alert also, the real-time alert can be either through email or on the registered mobile number. The real-time alert is not always on the registered mobile number. It can be either on the email or in the registered mobile number. Now, when it comes to mobile number also, the mobile number given at different time. So that also we have to be very careful to ensure that the proper mobile number is given to get the alert, and proper email ID should be given to get the alert well in time by the appellant. Now, shall be delivered to the addressee being any other person. So whenever it is to be delivered to any other person, it should be delivered to the registered email ID of such person, followed by a real-time alert. As I said that there is no requirement, or the personal appearance cannot be asked for during this appellate proceedings before the JCIT appeals. Now, whenever a JCIT appeal requires any statement to be recorded or the assessee requires the presence, it should be through video conferences or video telephonic conference only. So a person shall not be required to appear either personally or through authorized. Neither the assessee nor its authorized representative is allowed to represent personally before the JCIT appeals. Now the applicant or his authorized representative may request for personal hearing so as to make his oral submissions. Whenever he wants to make the oral submissions, he can request for personal hearing, right? Then if the request is made, the JCIT appeals shall allow the request for personal hearing and communicate the date and time of hearing to the appellant. Whenever a request is made, the JCIT appeal it is mandatory to allow the personal hearing, but the personal hearing shall be conducted through video conferencing or video telephony. It's not physical. Now, any examination or recording of the statement of the appellant or any other person shall be conducted exclusively through video conferencing or video telephony. Now, the recording of statement also required by the JCIT appeals, it should also be done through video conferencing and video telephony. The board shall establish suitable facilities for video conferencing or video telephony, as the same thing which is there in scrutiny assessment and CIT appeals. Now here also the same thing has been incorporated. Now the Principal Chief Commissioner of Income Tax, National Faceless Appeal Center. Principal Chief Commissioner of Income Tax, National Faceless Appeal Center, with the prior approval of board for effective functioning of the Office of JCIT Appeals set up under the scheme, shall perform the following functions. Now the National Faceless Appeal Center Principal Chief Commissioner will perform the following functions. What functions he will perform? Number one, he will transfer in and transfer out of cases from e-appeal scheme. From e-appeal scheme, from JCIT to CIT, from CIT to JCIT. So this will be done by the National Faceless Appeal Center. Then transfer of cases from one JCIT appeals to another. So this function also will be done by the National Faceless Appeal Center. Then we will coordinate with the Principal Director or Director General of Systems for devising process for allocation of appeals. Now when it is transferred to JCIT appeals, now there should be a process to allocate the appeals among the 100 JCIT appeals who have been recently appointed. Now, then the National Faceless Appeal Center approval of formats for notices for letters. The formats for notices or letters also should be approved. Then it will issue the standard operating procedures for various processes and for conducting video conference. For performing these functions, SOPs will be issued by the National Faceless Appeal Center. And any other procedural functions assigned by the board from time to time will be performed by the National Faceless Appeal Center. Now the Principal Director General or the Director General of Income Tax Systems. Now the Principal Director or Director General Income Tax Systems shall lay down the standards, procedures and processes for effective functioning of this scheme. Now relating to service of notice, what is the procedure of service of notice, service of order or any other communication, how it is to be served. Then receipt of any information or documents, in which fashion it should be received from the person in response to notice, notice or order or any other communication, how it is to be received. Then how to issue the acknowledgement of the response furnished by the person. Provision of e-appeal facility, including login account facility, tracking status of appeal, display of relevant details and facility to download. All these procedures and processes will also be designed. Now this also relating to this accessing, verification, authentication of information and response. All these things also will be designed. Receipt and storage and retrieval of information, any other function assigned by the board from time to time. Now, application of provisions of the Act. Now, whatever provisions are specified in the scheme, other than that, the provisions mentioned in these slides are also applicable for apply to the procedure in disposal of will by the JCIT appeals. Now, what are these provisions which are applicable? These are these provisions. Now, these jurisdiction of income tax authorities, change of incumbent, all these sections are also applicable for the e-appeals provisions, e-appeals scheme. Now, this is the one of the most important part of the presentation, which contains the scope of appeals. Here we'll go very slow, and if you have any doubt, you can just keep putting on the chat box. Right? Now, this is the scope of appeal. Now, this, as we know that section 246(6), the power is given to exempt certain class cases or class of cases from the purview of this e-appeals. So, exercising the power under section 246(6), this Central Board of Direct Taxes specified that all the appeals under section 246, and or section sub clause A, B, C, H, A, H, B, Q, 1 of section 1 of 246A. 246A relates to appeals before the CIT appeals. 246 relates to appeals before the JCIT appeals. Now, all the appeals contained in section 246 and some of the appeals, orders, appealable orders contained in section 246A subsection 1 are notified for inclusion in the scope of appeals before the JCIT appeals. Now, these are the orders under section 246, which we have already dealt. Now, these are the orders which will be appealable before the JCIT appeals. All these orders contained in section 246, all these orders will be appealable before the JCIT appeals. Right? Now, major in this, what I find is section 143(1)(a), 143(3), subject to certain monetary limits, section 143 or 144 subject to certain monetary limits, section 147, then 200(a), all these TDS and TCS cases, and 143(1)(a). Then rectifications relating to these orders, and then subject to certain dates and monetary limits, assessments passed under 143(3) and 144. These are all contained in section 246, which are appealable before the Joint Commissioner appeals. This we have already discussed in my previous slides. Now, what is section 246(a)(1)? Now, 246(a), as we all know, relates to orders appealable before CIT appeals. Now, here also, subject to certain conditions, some of these appeals will go before the JCIT appeals. Now, what is 246(a)(1)? Any assessee or any deductor or any collector, deductor of tax and collector of tax, TDS and TCS, aggrieved by any of the following orders, whether made before or after appointed day, may appeal to the Commissioner appeals, may appeals against an order passed by the Joint Commissioner appeals under section so and so. These sections also I will refer. Now, here I have a confusion or doubt to what I say. Now, here this 246(1)(a) is included in JCIT appeals. this includes an order passed by a joint commissioner appeals under so and so. So when an order is passed by joint commissioner, it cannot be appealable before the joint commissioner. But I don't know how it has come into that. It has missed the attention, or some amendment will come, I don't know. But because the appeal before the joint commissioner will lie only if the order is passed by an officer below the rank of joint commissioner. So this particular order, when it is passed by the joint commissioner, how it got included in this, I don't know. But these sections, mostly these sections are related to these sections. I'll take you like this. Now section 115 VP relate to method and time of opting the tonnage tax scheme. The orders relating to tonnage tax schemes. Now 143(1) intimations relating to processing of returns. Then 143(1)B relating to processing of returns. Then 200A processing of statements of TDS. Then 206CB processing of statement of tax relating to tax collected at source. Then 143(3) relating to scrutiny assessment. Then 144 relating to best judgment assessments. So all these assessments subject to certain monetary limits. Some of the things relating to 143(3) and 144, some of the exceptions are there. But as far as 143(1) is concerned, 200 is TDS, TCS, and intimations are concerned, all orders will now be appealable before the JCIT appeals, and the existing appeals relating to pending before the CIT appeals will also be transferred to the JCIT appeals relating to these sections. Now, in this section 144BA subsection 12 is excluded because these sections, the orders are passed with the prior approval of principal commissioner or the commissioner. So whenever the orders are passed with the prior approval of the principal commissioner, as we know that logically it cannot be appealable before the joint commissioner appeals, because he is below the rank of the commissioner and principal commissioner. Now, an order of assessment or reassessment under section 147 or section 150 relating to income escaping assessment, or where an assessment is made in pursuance of order of appeal or revision. These order are also appealable before the JCIT appeals, like in CIT appeals. Now, section 154 or section 155 orders relating to rectification of under these sections will also be appealable before the JCIT appeals relating to the orders which are appealable. All rectification orders relating to appealable orders are also appealable before the JCIT appeals. Now, an order made under section 201, as I said, that it is a failure to deduct or pay tax. Then 206C, failure to collect or deposit TCS. These orders will lie with JCIT appeals. It is included in JCIT appeals case. Now, an order imposing a penalty under chapter 21. This is also appealable to JCIT appeals, subject to certain conditions, which I am going to deal in the coming slides. Now, these are the orders. As I was mentioning just a slide before that, these are the orders which are specifically excluded from the JCIT appeals purview. Now, here we have to just see it carefully. Now, appeals against assessment orders passed before 13/8/2020. Now, whatever appeals are lying with the CIT appeals against the assessment orders passed before 13/8/2020. What is the relevance of 13/8/2020? 13/8/2020 is the date of introduction of faceless assessment scheme 2019. So before the orders of assessment under section 143(3) or 144, assessments passed under 143(3) or 144 before 13/8/20, where the disputed demand is more than 10 lakhs, are excluded from the purview of JCIT appeals. orders passed before 13/8/2020 under section 143 or 144 having disputed demand of more than 10 lakhs are excluded from the purview of JCIT appeals. As in the memorandum, the finance minister said that only the small amounts, as I dealt in the first slides only, that finance minister said that involving cases, certain class of cases involving small amount of disputed amount. So the small amount of disputed amount will only be transferred to the JCIT appeals. This was the purpose of introducing this authority. So now the demands less than 10 lakhs will be passed before this date will be excluded from the purview of JCIT appeals. Now, the appeals related to assessment orders passed with respect to cases pertaining to the jurisdiction of Commissioner of Income Tax Central. Now, search and seizure assessments. Now, the cases which are lying with the central circle will not be transferred to the JCIT appeals. It will remain with the CIT appeals. So, all cases relating to CIT Central Commissioner, the jurisdiction will not be transferred to JCIT appeals. Now, all search and seizure cases under 132 and all these cases under 132A, section 132A, this also will remain with CIT appeals. This will not be transferred with JCIT appeals. Then the assessments completed in pursuance of section 133A relating to survey. All survey cases assessments, any appeal pending before the Commissioner of Appeals relating to survey cases will also remain with the CIT appeals. It will not be transferred to the JCIT appeals, or new appeals under these sections also will be appealable before the CIT appeals and not before the JCIT appeals. Now, the assessments where additions, variations, income is made on the basis of seized and impounded material, section 153 cases relating to search and seizure and relating to 153C cases will also be lying with the remain with the CIT appeals and not will be not lying with the JCIT appeals. And the appeals relating to cases pertaining to international taxation will be remaining with the CIT appeals. It is excluded from JCIT appeals. Now, appeals against the penalty orders. Now, the penalty orders passed before 12/1/2021, which is the date of introduction of faceless penalty scheme with respect to cases referred in category 1. What is category 1? Relating to assessments where the demand is more than 10 lakhs. So, if in such cases where the penalty is also having a disputed demand of more than 10 lakhs and the assessment is having a more than disputed demand of more than 10 lakhs and the penalty orders are passed before 12/1/2021, these cases will remain with the CIT appeals. These are excluded from the purview of JCIT appeals. Appeals against the penalty orders passed in categories of cases mentioned in the below points will again remain with the JCIT CIT appeals, excluded from JCIT appeals. These are all relating to search and seizure, international taxation, 153 survey. All these cases, penalty cases also will be excluded from the JCIT appeals jurisdiction. Now, appeals relating to assessment orders passed on or after 12/9/2019, which is the date of introduction of e-assessment scheme. Under the e-assessment scheme 2019 or the faceless assessment scheme 2019 or section 144B. These are also excluded from the purview of the JCIT appeals. Now, appeals against the penalty orders passed on or after 12/1/2021 under faceless penalty scheme, all orders relating to with respect to of the amount, quantum will be excluded from the purview of the JCIT appeals. Now, when you after that when you just go through this slowly, all these things, now you will get clarity on this point. If you have any other things also, you can just contact me through mail so that I can give you more clarity whenever required. Now, what is this? Whenever we were dealing with the amount of 10 lakhs, it was mentioned that it relates to disputed demand more than 10 lakhs. So what is the disputed demand? Here it is disputed demand, it's not disputed tax. So disputed demand, what is the disputed demand? Disputed demand means the difference between the tax on income assessed and the tax on returned income. So whenever a return is filed, the assessed, the demand as per the income assessed and demand as per the income return. The difference is the disputed demand. And whenever there is no return filed, so the tax on income assessed is the disputed demand. Now, as far as penalty order is concerned, whatever is the penalty imposed is the disputed demand for the purpose of this scheme. Now, the demand raised under section 146 in any other case other than the assessment and penalty, in any other case like 143(1) or TDS, TCS intimations, those cases, the demand raised by notice under section 156 will be the disputed demand for the purpose of this scheme. Now, in this case, as I said, it is a disputed demand. So, the disputed demand shall include the interest, not only tax, that tax, interest, surcharge, and cess. Everything is included for in the definition of disputed demand for the purpose of this scheme. Now, these are some of the rules which have got amended. So, this I am not taking into detail because this will not be very interesting to you. So, anyway, I have included in my PowerPoint. You can just, when it is passed on to you for ready reference, I have included here. You can go through the same whenever you require. Now, these are the Joint Commissioner of Income Tax authorities which have been appointed. Now, they were appointed on 7th June. 7th June. Now, these are the 100 income tax, the Joint Commissioner Income Tax authorities have been appointed all over the country. Now, this city-wise, it is mentioned like Hyderabad 4, Jaipur 2, Kolkata 7. Like this, it is mentioned. Now, there are 100 JCIT appeals, Delhi 12, Mumbai 13. So, total 100 JCIT appeals have been appointed, and I was told that mostly these JCIT appeals are the rank of additional commissioner. Now, this is form number 35 has also been amended accordingly. So, just I have put this form 35 incorporating this Joint Commissioner of Appeals in addition to Commissioner of Appeals. So, appeal form is same form 35, only the authorities of Joint Commissioner Appeals have been incorporated into this. And the most of the procedures is also same. Now, we will go for question and answers, if you have anything. So, question answers, one, Jayesh. Mr. Jayesh is asking, proceedings can be transferred from CIT appeals to JCIT appeals. Yes, proceedings can be transferred from CIT appeals to JCIT appeals. Also, while filing appeal, taxpayer needs to choose with whom appeal should be filed, whether CIT appeals or JCIT appeals, or system will automatically allocate. Very good question, and this question has come to my mind. If it was not asked, I should have told this. Now, I will tell in detail this. Now, this first part of your question is proceedings can be transferred. Yes, the proceedings can be transferred from CIT appeals to JCIT appeals in respect of existing appeals, where the jurisdiction is freshly lies with JCIT appeals. So, it will be transferred from CIT appeals to JCIT appeals. Now, while filing appeal, taxpayer needs to choose with whom appeal should be filed. Now, this, when we see the scope of appeal, it will be clear where the appeal will lie. It is very clear from there. As you have put the question maybe early, this point might have arisen to your mind earlier. But now, when I covered the scope of work, it might have got cleared. Anyway, if you refer that, it will be very clear. And now your question is, or the system will automatically allocate the appeal? No, the system will not automatically allocate. Now, one point is that we will be knowing, depending upon the section under which the order is passed, appealable order is passed, where the appeal will lie. And second, the 156, the demand notice will also specify where the appeal will lie. So by that, we will be able to know before whom we have to file the appeal. I think I have clarified your point. If you have anything, you can just put once again any question by way of continuity to that. Now, Mr. Abhishek is asking whether for one assessment year, two appeal before CIT appeal can be filed. One for order under 143.1 and another one for 143.3. 143.1, yes, 143.1 is a separate section, and the appeal might have got filed earlier in respect of 143.1 when the return got processed. Now, meanwhile, there may be situation that the proceedings under 143 it got converted under one scrutiny, and 143.3 order is passed. So against that also separate appeal will be filed. But whenever we are filing the second appeal, we have a column to mention that if any other appeal is lying before the for the said assessment year before any other appellate authority, there we have to put that fact. Now, I think there are no other questions. I'll just check up whether I wanted to cover anything else. This appeal I told. Then one more is Mr. Tirunapalli Shankarlingam Pillai, Jankiramji. Jankiram sir is asking one question. Assessing officer should mention in the scrutiny order that the assessee aggrieved by the order passed by the AO can apply to the appellate authority. Yes, it will be part of the demand notice under 156. It will be mentioned that an appeal will lie before a particular appellate authority. It will be written. I think this time is also 6 o'clock. I feel that we are generally not exceeding the time in our webinars. So if any other question is there, otherwise I may conclude. If you have any other queries, you can just write to our email IDs, or you can write to Taxmann. They'll be sharing my presentation. So thank you, everybody. I am thankful to all the participants who joined in good number to listen to this presentation, and the Taxmann, all the team of Taxmann, for giving me an opportunity to present this topic before you. And this being the latest topic, I also got benefited very soon by going through all these provisions of the Act. Now, thank you. Hope to meet you again. Thank you, one and all.